Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company, and the topic for today's second video presentation is statutory arbitration, which is quite an important concept under arbitration. So, in cases of statutory arbitration, the statute controls the procedure and appointment of arbitral tribunal. It is distinct from the original form of arbitration. It is different from original form of arbitration, and a statute may provide for disputes of particular class shall be determined by the procedure prescribed in the Act only. The arbitral tribunal constituted under the Act shall have exclusive jurisdiction over such disputes. The statutory arbitration is imposed upon the parties by virtue of the provision contained in a particular statute. Here, the source of arbitration does not emanate from an agreement between the parties, but the statutory provisions applicable to the contractual relationship between the parties. Examples of acts having relevant provisions of statutory provisions are Electricity Act, Telegraphs Act, Small Scale and Ancillary Industry Undertakings Act, etc. Section 2, Clause 5 of the Arbitration and Conciliation Act, which is subject to the provisions of subsection 4 and save in so far as in otherwise provided by any law for the time being in force or in agreement between India and any other country or countries. Section 2, Clause 2 says that this part shall apply where the place of arbitration is in India, and section 2 clause 5 says that this part shall apply to all arbitrations. Further, section 3, which is receipt of written communications, section 3 talks about unless otherwise agreed by the parties, any written communication is deemed to have been received if it is delivered to the addressee personally or at his place of business. Second, if none of the places referred to in clause A can be found after making a reasonable inquiry, a written communication is deemed to have been received. It is sent to the addressee's last known location. The communication is deemed to have been received on the date of it is so delivered. And lastly, this section does not apply to written communications in respect of proceedings in any judicial authority. In any of the judicial authorities. So, section 3 starts with the phrase unless agreed by the parties. This phrase indicates that it is open to the parties to decide their own procedure. Section 3 has relevance moreover arbitration, because the arbitral institutions usually prefer their own procedural rules over non-mandatory provisions of this section. Further, moving ahead, section 3 clause 1 subclause A of the Act provides for any written communication is deemed to have been received if it is delivered to the addressee personally or at his place of business, habitual residence or mailing address. It is therefore crucial that the delivery of the written communication must be established. So, Section 3 clause 1 subclause A uses the expression after making an reasonable inquiry. Act does not define what is reasonable inquiry. Keeping in mind that this Act does not define the reasonable inquiry, but it simply means that a reasonable effort should have been made to inform the addressee so that he is given an opportunity to exercise his rights. Further, under statutory arbitration, section 3 under statutory arbitration, there is a presumption under section 114 of the Evidence Act that the notice was duly served upon the addressee. Section 114 of the Evidence Act, which states that the court may presume existence of certain facts The court may presume the existence of any fact which it thinks likely to have been happened regarding being had to common course of the natural event, of the happening of the natural events. And further, section 4, which talks about waiver of right to object, and what constitutes waiver. Waiver is constituted by the deliberate, intentional and unequivocal release or abandonment of a right under the contract or a derogable provisions of the statute. In principle, waiver would not need to be intentional. There can be no waiver of non-derogable mandatory provision of the statute. So this was the basic concept and idea of statutory arbitration, and I hope I was able to give you guys a basic idea about it. Thank you.